My name is Ruth Jordan, and today I will be talking to you about the right to be forgotten, accessibility and description in the digital age. As more information is created and digitized, archivists are having to grapple with individuals' privacy rights with the mandates of their profession. The International Council of Archives, the ICA, serves as the framework for many countries' archival codes of ethics, including those of the Society of American Archivists. In part, the ICA states that archivists should take care that corporate and personal privacy as well as national security are protected without destroying information, especially in the case of electronic records where updating and erasure are common practice. They must respect the privacy of individuals who created or are the subjects of records, especially those who had no voice in the use or disposition of the materials. The Society of American Archivists has a similar code in that archivists are to actively promote open and equitable access to records in their care as much as possible, while recognizing that privacy is an inherent fundamental right and sanctioned by law. Archivists are to protect the integrity and access of their records, while protecting the privacy of the people in those records. More and more personal information is being disseminated to a larger community as archives are putting more online. Richard J. Cox and David A. Wallace, authors of Archives in the Public Good, Accountability, and Records in Modern Society, state that privacy and access to information may be the distinctive hallmarks of the modern information age, and as a result, archivists and records managers should have pivotal roles to play. However, as more archives create digital content to preserve materials and increase accessibility, ethical concerns have grown, as it could spread information beyond its intended reach. Katrina Winden and Joshua Youngblood, librarians at the University of Arkansas, used the example of posting a picture of a protest movement, noting that such a picture could cause reputational or personal harm depending on the circumstances of the protest. The digital age has magnified the archivist's role in balancing how much information to describe in their collections to create accessibility and interest, while also maintaining the privacy of the individuals named or pictured in those collections. To balance privacy rights in the digital age, the European Union created the General Data Protection Regulation, the GDPR, to help individuals gain more control over their digitized personal data. It provides organizations and institutions with rules and guidelines for ethically storing and maintaining the digital data they collect. Article 17, known as the right to erasure or the right to be forgotten, specifically addresses the individual's rights. There are several grounds for the requested erasure of personal information, such as when it is no longer necessary or when it was collected illegally. However, archives are granted some exceptions due to public interest and for historical research. Still, that has not stopped individuals from asking to have their names or other personal information removed from an archival collection. To understand how the right to erasure is affecting archives in the EU and the UK, if at all, an informal survey was sent out to archives in 15 European countries. These were sent to a range of institutions from local city archives to national archives in some countries. Of the 50+ surveys sent, roughly 11 archives have responded. The first two questions addressed whether archival practices changed after the GDPR, and the third asked about concerns about the future of description and access under the GDPR. The last question was to understand how they handled requests for erasure. For description, the overwhelming answer was no, it has not changed at all. Most respondents stated, due to archival practices already in place, whether through the institution's policies or their country's privacy laws, descriptions are kept relatively top level and general in detail to maintain privacy. Paul Epelace, archivist for the Museum of Gothenburg in Sweden, stated that although practices have not changed, there is an awareness of the regulation and a bit of confusion of how it interacts with other regulations and laws. In some cases, people tend to think that the right to erasure surpasses other laws that regulates archival procedures, which it doesn't. Access was similar in that archives were already heavily regulated due to their own country's laws. An archivist in Ireland stated that the GDPR prompted many archives to adopt a written access policy. As this is good practice for any archival institution, whether in the US or Europe, most would probably already have an access policy in place. The question of the future of description and access after the GDPR had many different responses. Most were not concerned, but a few noted that with more digital content, description and access could be made more complicated. This seemed to be a larger concern from local archives because they were more likely to collect newspapers and other materials from people who were still living. An archivist from England noted that changes to archival description could make future collections less effective and less impartial. Finally, a few archivists reported instances of people asking to have their names removed from archival collections. Jan Kudov, archivist at the Noord-Hollands Archive in the Netherlands, stated that there was a request from Holocaust victims to have their names removed from an archive, which was granted. However, he said this was an exception given the circumstances. In another archive, Joanne Smith from the Southampton Archive in England explained that a person asked to have their name redacted from a newspaper. This request was denied because removing the article would damage the document and removing a whole reel of microfilm from public use was not an option. She did say that if the newspaper were ever digitized, the request would be revisited. Finally, although not directly due to the GDPR, it should be noted that since 1987, Germany has allowed people to add a counterstatement to their record that names them, but they cannot have their personal information removed. From these answers, it is clear that EU archivists must balance individual privacy, laws and regulations, and their own professional mandates to maintain the integrity of the records in their care. As more laws protecting personal data proliferate and the volume of digital content grows, archives will continue to receive requests to redact personal data. As such, this can create some unintended implications. In 2016, Antoon de Baets, a history professor in the Netherlands, wrote that a generalized right to be forgotten would lead to the rewriting of history in ways that impoverish our insights, not only into anecdotal lives, which is justified in a small class of recent cases, but also into the larger patterns and trends of history. Shelley Black, an archivist in North Carolina, wrote that people with more resources may be more likely to request the redaction of their information due to incriminating or embarrassing information than those in marginalized communities, which could potentially skew how history views public figures or people in power. Historians and archivists have also voiced concerns that removing personal data now could have long-term effects on historical research, as many documents gain historical significance long after their creation. Furthermore, archives and libraries are concerned that removing personal data will hinder online historical and genealogical searches, potentially limiting accessibility. Collections must remain as intact as possible to maintain their historical significance and accessibility, while being mindful of people's right to privacy. This subject will continue to be addressed and evolve as more information is created, appraised, and digitized in the coming decades.